Preventive detention. Preventive detention is when the government looks at you and says, "You look like you're about to do some bad things. Let me arrest you just in case." This is against every principle of justice and fairness. All criminal laws tell you what you shouldn't do and what the punishment is for doing the thing. There is a process followed where anyone accused of committing a crime is arrested, brought before a court of law, and allowed a chance to defend themselves. Until it is proved beyond reasonable doubt that the accused has committed the crime, there remains the presumption of innocence. When a person is accused of committing a crime, they are one person against the might of the state. So, there are many safeguards that are in place to protect the rights of the accused. If it were not so, any person who falls out of favor with the government could be locked up and deprived of their rights. During the struggle for independence, many freedom fighters were detained in inhumane conditions using preventive detention laws. We struggled against colonial rule to rid ourselves of oppressors, and we yearned to achieve independence and longed to be free. So, when independence was achieved and a constitution was to be written, it was decided to give special protections for preventive detention laws. Wait, that doesn't even make sense. Article 22 of the Constitution of India provides for protections against arbitrary arrest. Clause 1 says, "No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice." Okay, good so far. Clause 2 says, "Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate." All good so far. Then comes Clause 3. "Nothing in clauses 1 and 2 shall apply to any person who for the time being is an enemy alien, or to any person who is arrested or detained under any law providing for preventive detention." So, what Article 22 says is that you cannot be randomly arrested unless you are arrested under a law that allows the government to randomly arrest you. Sounds about right. The nation that was formed by the people after decades of struggle against authoritarian rule had just protected a tool of oppression in its highest law. Then there is clause 4 that says, "No law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months unless an advisory board consisting of persons who are or have been or are qualified to be appointed as judges of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention." So, as long as sufficient cause can be manufactured, a person can be detained indefinitely without having committed a crime. Then there's clause 7, which allows the government to make preventive detention laws under certain circumstances. There have been many laws enacted by the government under this clause. While preventive detention laws have historically been used to crush political dissent, the excuses made for these laws have evolved over the years. The infamous Rowlatt Act in 1919, which gave excessive powers to the police to suppress anti-government ideas, has a rather interesting title. It was called the Anarchical and Revolutionary Crimes Act. It makes clear that the intent of the act is to criminalize any activity that the government considers against their interests. It made peaceful protest impossible, met widespread opposition, and eventually had to be repealed. This was a lesson learned for the governments that came after, not in refraining from enacting draconian laws, but in how to package them to garner public acceptance. The new laws were made ostensibly to further interests such as national security and public order, but it is obvious from the execution of these laws that the primary goal is to get activists to shut up. In this line, the most recent stain on our democracy is the Unlawful Activities Prevention Act of 1967. According to the Statement of Objects and Reasons of the Act, it imposes reasonable restrictions in the interests of the sovereignty and integrity of India. Both nebulous concepts that could mean almost anything that the government wants it to mean. These restrictions are to be imposed in the freedom of speech and expression, the right to assemble peaceably and without arms, and the right to form associations or unions. Why is an act intended to prevent unlawful activities targeting the 3 pillars of peaceful protest? Let's find out. There are so many patent absurdities with this act that I'm unsure where to begin. Let's start with the name, Unlawful Activities. Okay, it's a criminal law, so it deals with unlawful activities. What does it do with these unlawful activities? It prevents them. Meaning that before someone even commits the unlawful act, the government will swoop in and prevent it from happening. Because the government can read everyone's mind. Right. And what are these unlawful activities? The Act defines an unlawful activity as any action taken by an individual or association, whether by committing an act or by words either spoken or written, or by signs or by visible representation or otherwise, which is intended or supports any claim to bring about on any ground whatsoever the cession of a part of the territory of India or the secession of a part of the territory of India from the Union, or which incites any individual or group of individuals to bring about such cession or secession, or which disclaims, questions, disrupts, or is intended to disrupt the sovereignty and territorial integrity of India, or which causes or is intended to cause disaffection against India. The first two subsections seem to be extensions of anti-sedition law. This is a broad definition that leaves room for the voicing of any grievance against the government to be considered an unlawful activity. With the tendency of the government to label every criticism as anti-national, the third clause especially is extremely problematic. It could easily be abused to pack off dissidents to prison. The punishment for committing an unlawful activity can extend to 7 years. Normal criminal laws work by prescribing punishments for doing certain things, like the Indian Penal Code, or they provide guidelines for prosecution of the criminals, like the Criminal Procedure Code. The Unlawful Activities Prevention Act, however, seeks to stop crimes before they even happen. So, how does it seek to do that? It does it by enabling the central government to point at someone, say that they're thinking of committing a crime, and throw them in jail. In classic Orwellian fashion, this act has essentially criminalized thought. Section 43A, inserted through an amendment following the 2008 terror attacks, reads as follows. Any officer of the designated authority empowered in this behalf by general or special order of the central government or the state government, as the case may be, knowing of a design to commit any offence under this act, or has reason to believe from personal knowledge or information given by any person and taken in writing that any person has committed an offence punishable under this act, or from any document, article, or any other thing which may furnish evidence of the commission of such offence, or from any illegally acquired property or any document or other article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under this chapter, is kept concealed in any building, conveyance, or place, may authorize any officer subordinate to him to arrest such person or search such building, conveyance, or place, whether by day or by night, or himself arrest such a person or search such a building, conveyance, or place. Knowing of a design to commit any offence under this act, or has reason to believe from personal knowledge. Personal knowledge. The officer just has to take one look at the person and just knows that the person is going to commit a crime. And so the person is arrested. Keep in mind that no crime needs to be committed. The officer just needs to think that the person has plans to commit a crime. Couple this with a police force which has acquired great renown for its brutality, and you have the perfect mechanism to silence vocal citizens. To top this all off, there is Section 35, which allows the government to designate an organization as a terrorist organization and throw all of its members in jail. Now, with the 2019 amendment to the Act, even individuals can be arbitrarily named terrorists, have their lives and reputations completely destroyed, and their voices silenced with little to no oversight. Time after time, the government proves that the Act exists for the unjust detention of activists. Arun Ferreira, an activist for the cause of socially marginalized groups, spent 5 years in prison and in solitary confinement before eventual acquittal. Binayak Sen, the national vice president of the People's Union for Civil Liberties, was arrested under the act. Thirumurugan Gandhi, who addressed the 38th session of the United Nations Human Rights Council about the police firing into crowds of protesters who were rallying against the reopening of a polluting sterlite plant in Thoothukudi, was arrested upon his return to India and was booked under the act. The list goes on, and there can be no denying that far from preventing any unlawful activities, the act is used overwhelmingly to silence those who speak up against the government. The most recent high-profile case is that of Safura Zerga, a student activist who was arrested with the accusation of being involved in a sinister design with the objective of uprooting a democratically elected government. Her crime? Protesting the anti-minority activities of the current central government. A democracy does not function without an opposition. To conflate anti-government speech with attacks against the nation and to treat criticism as crime is fatal to a democratic state. We now live in a country where speech is shackled by threats of violence by the state. If we want the Indian experiment with democracy to stand the test of time, we must not let the quiet voices be silenced.